You don't recommend staying in a lawsuit just on the hopes of recovering attorney's fees, do you? Or what do you think?
No, definitely not.
Uh,
At some point, and it's not fair, and I can't empathize with the clients. Like, hey, you've had to hire me, you've had to go through all this that you don't feel
mm.
like you should have, and maybe you shouldn't have, but you are in it. This is how it goes, and this is just what you're stuck with.
Welcome to episode 88 of the Weekly Docket, a podcast by the Silberman Law Firm. Today is September 19th, 2025. I'm Phil Silberman, owner of the firm and your host, and I'm joined by Chris Heald, who is our firm's supervising attorney. Chris, I played tennis last night, and I met a guy I met a couple times, actually. He was my partner, and he's an attorney. I played against him, rather. He's an attorney at a big firm. And unsolicited after the match, he just asked me, can you guys keep associates at your firm? And he's at a big firm, real estate type practice. And I told him the turnover is definitely higher than it's been in years past, and it's challenging. He flat out said they just cannot keep associates. So something we've talked about in the past. So I just thought you'd find that somewhat interesting.
It is interesting. So it seems to be a recurring theme of ours. So
Yeah.
that is interesting to hear.
I looked his firm up, and I don't know that Law Crossing is right, but it's a website that kind of tracks attorney salaries. And they were starting their first year associates out at 180 grand. And I would suspect they're asking for 2,000 to 2,200 billable hour requirement. Okay. And for people who don't understand, that's basically working 50 weeks a year, billing 40 hours a week. So how many hours a week would you estimate in time that associate has to work to get to 2,000 hours? So would you say,
I can't, I'll let you do the math, but I remember my friends right out of law school that took those big firm jobs. I think the expectation they would be there around 7:30, 8 o'clock in the morning, and they wouldn't leave till 8 or 9 o'clock at night.
Yeah, that's a lot of hours. That's 12 hours a day. If they do that 5 days a week, that's 60 hours. And then you figure they're working some on Saturdays too. So you could probably call it 65 to 70 hours. The young people coming out of law school, they just don't want to work that much for that kind of money, Chris. And I guess they're looking at it as, well, yeah, you're paying me 200 grand a year, but you're asking me to work 2 jobs. So I don't want to do it.
No, I think that's probably right. A lot of us watched our parents work themselves to death and not have anything to show for it other than a life of work. And so people have kind of realized that it's not all about acquiring money. I can take a lower salary for more free time. It's the thing we always talk about, that we always hear, is everybody's in work-life balance.
Well, with that whole parent comment, Chris, I think I'm like thoroughly depressed now.
We are those people.
Okay. Let's go ahead and, before I get any more depressed, let's go ahead and talk about what's on our docket today. We're going to cover this thing called House Bill 21. It just went into effect September 1st. It closes this kind of insane real estate developer loophole. So we'll talk about that. And then in our legal question section, you're going to help us answer the question, Chris, answer the question of how to get an out-of-state guardianship approved in Texas. And then finally, in our rant and rave section, we'll be talking about a big client misconception about recovering attorney's fees. So let's get it kicked off with our legal news section. And this one's obscure, so I'm going to have to carry the team on this one. House Bill 21, this traveling loophole. Chris, follow me on this.
Do my best.
All right. So this law in the local government code, it was chapter 394 of the local government code. It came out some time ago, and it allowed for the creation of these things called housing finance corporations. And they're quasi-governmental entities, and they're created or sponsored by cities or counties. And what they do is they help encourage and facilitate affordable housing, like an apartment complex that's going to be affordable housing. And in exchange for the developers doing this, they basically get to pay zero property taxes. So that's a huge boon for real estate developers. Everyone thought this was an amazing idea, but it turns out there was this loophole in the law that effectively worked like this. If you were, say, a smaller city like Waco, for example, you could sponsor or create an HFC, a housing finance corporation, and then the developer could go build that project in Houston or Dallas. And all of a sudden, if this thing got built, sponsored by Waco, built in Houston, and the city of Houston is, wait a minute, we did not approve this, and we're not getting any tax revenue off this. And now we have to provide the fire services and police and all this kind of stuff, and we're not getting any money for it. So it was a huge problem. And what House Bill 21, first of all, Chris, do you see that as a problem?
I can see that as a problem.
Okay. I think everyone agreed with that except the real estate developers. So House Bill 21 meant to roll that back and say that was a loophole. We never intended for this to happen. Or if they did intend for it to happen, we never intended it to be this out of control. Excuse me. House Bill 21 got passed and it closed that loophole. And then there's been this, I don't know what it is, some kind of nonprofit that's basically that represents all the big real estate developers. They're suing saying that House Bill 21 making that correction is now illegal or unconstitutional. And the state of Texas is like, no, we can do this. And what do you think? That good law, Chris, House Bill 21 squarely within Texas legislature, state of Texas, squarely within the rights to say, no more loophole.
Are they scrapping the whole program or what are they?
No, they're just,
I'm not sure I'm following.
They're not scrapping the whole program. They're just saying you no longer get to have some obscure city. You no longer get to have like Beaumont sponsor a project to be built in Dallas. You can't travel. You have to, if Beaumont sponsors the project, the housing affordability apartment and the affordable housing apartment complex has to be built in Beaumont. You no longer get to travel with them.
Yeah, I mean, that would make sense. I've never heard of a city allocating funds to a project in another city. Are there no funds involved?
I don't think there are any funds involved technically from the sponsoring city, or else you would assume they wouldn't do it. I think
So why have a sponsoring city at all? What's the point?
I think that was just part of the local government code that you had to have some city or county sponsor this thing.
Yeah. Oh, so they forgot to just specify that the municipality sponsoring it must be the place where it's located.
That would put it in its best light.
So you're Waco and you're saying, yes, we approve this project and we understand that you will not be paying taxes to us. Mm-hmm. And we're okay with that because we believe the public benefit to outweigh that by giving people who can't afford housing, giving them houses. That's going to be a much better thing for our city than some missed tax revenue.
Yeah, that's what you just explained would be the common sense approach. I have no idea how this got out of control. You can only assume that sort of some big lobbyist for real estate maybe originally tried to get that thing passed because nobody wants to build affordable housing in, say, the middle of nowhere in Texas. You want to build it in a big metro area where you've got high demand for apartments.
It doesn't surprise me. We obviously work a lot in real estate, and real estate's an area where a lot of people try to get in and make some money. So everybody's looking, and I hate the term loophole, but maybe it's appropriate here. Yeah. Everybody's looking for something no one else has seen before or an opportunity no one else has spotted before. So it doesn't surprise me that when you pass something like that, you're going to have people examining it and going to lawyers and saying, hey, I have this idea. Because you and I get that all the time. They say, hey, I can't think of the latest idea. Maybe it's been a while, but people call us, right? And they say, hey, I've got this idea. I think the property code allows me to do that. And sometimes we look at it and we say, hey, you might be right. And you might be right today and the court may shut you down tomorrow. But I hear what you're saying. If you think this is an oversight that you can exploit, I'm not here to tell you can't. So these real estate investors get pretty savvy sometimes, maybe a little too creative sometimes.
Yeah, I agree. I think this new law makes sense. So it's probably going to stick. All right, let's move on to our legal questions section. And Chris, you're primarily a probate expert. You're an expert in all of our practice areas now, but you have a special love for probate. And this question came out, how do you get an out-of-state guardianship approved in Texas? And they're basically asking, Chris, how do you get it? And this is me speaking the legalese into it. How do you get a guardianship order from another state domesticated in Texas under the full faith and credit clause of the United States Constitution? What do you say? You want to take a stab at it?
I guess I've never thought about it in those terms. I think there's just a procedure in the estates code that says if you're already a guardian, you just file your application here and you're basically trying to transfer it. You get the old state to agree to the transfer. You get the new state to agree to the transfer. You have a hearing similar to what you would have otherwise, except you don't have to prove that the person's incapacitated because you've already done that. But Texas is still going to want to make sure you qualify under the same standards as other Texas guardians, just in case some of those West Coast states might have more lax requirements. I doubt it, but Texas is still going to make sure you're qualified. They're going to look at your documentation, make sure the person's been adjudicated to be incapacitated, look at where the ward is living now. And if they're living in Texas, they're just going to go ahead and transfer it over here. Because if your ward is here, you're going to need Texas letters of guardianship, because you bring your California letters to a hospital or a nursing facility, they're going to say, wait a minute, this says California. We need something that says Texas.
All right. Yeah, absolutely. It's called an application for receipt and acceptance of foreign guardianship. It's a state's code section 1253.051. I did not know you had to have the other state involved. Chris, is the process we're talking about, is it less expensive or more efficient than just doing a guardianship from scratch, or what do you think?
It's probably similar. If you've already got a guardianship created in another state, you've got to go through this process, because if you were to start from scratch, you just wouldn't be following the right procedure. When you're starting from scratch, you always have to claim there is no other guardianship pending. If there is another guardianship, you need to say so. But yeah, they want all the records from the prior court. That's about the only involvement, is the other court saying, yes, we relinquish that. Because think about it the opposite way. We wouldn't want a California court just telling a Texas court, hey, this is our guardianship now.
Yeah, we don't.
Texas is going to say, whoa, wait a minute.
Yeah.
It's not your guardianship till we say it's your guardianship.
We don't want the state of California telling us anything.
Right. So they're going to be the same way. The Texas court's not going to be able to say, this is our guardianship now. California is going to have to say something about it first.
All right. That brings us to my favorite part of the show, our rant and rave section. And we're talking about a client misconception about recovering attorneys. Chris, you get these calls, we get them, clients have been sued, they say they've wrongfully been sued. You always hear that term, frivolous. It's a frivolous lawsuit, and they want to know if they can recover attorney's fees. What do you tell them, Chris?
I tell them attorney's fees are never guaranteed. Oftentimes it's something that's on the table. You may have a written contract that provides that the winner gets their fees. You may have a statute that provides for attorney's fees. But I definitely start by explaining this is not a winner pay or a loser pays system. I think you're right. There is a misconception that if I win, the winning party gets their fees. And that's simply not the case. In law school, we learned that's the British system, but it is not the American system. So maybe that's where the conception comes from, that, hey, loser pays. If I win, I get my fees. But I certainly have to caution everybody, it's not that simple.
Yeah, no, 100%. And if they're going to have something, you have to have some type of law. You're talking about DTPA or the breach of contract where there's a law, or expressly in the contract where you get statutory attorney's fees. Keeping with the issue of a frivolous lawsuit, we do have a 91A motion process in Texas where we can have it dismissed if it was really a baseless lawsuit without any kind of merit. And in that case, it even says, and this was a recent change in the law, it says the court may award attorney's fees. So it's permissive.
Which is weird, because the whole thing used to be, hey, if this is actually determined to fit under 91A, this is a frivolous lawsuit. You did not even state a claim on which the facts you pled could result in liability on the other side. That's how bad your pleading was. It used to be, hey, you're going to pay fees. And they walked that back. 91A was definitely intended to make people withdraw their claims if it was actually true that, hey, this is a 91A, you go to this hearing and you lose, you're going to pay. We're going to give you, I think it was, you had 3 days or maybe 7, but I think it was 3 days before the hearing you had to withdraw your pleading and you're off the hook. Yeah. And they're trying to lessen the burden on the judicial system by really scaring you into that, saying you can come, but if you lose, you're going to pay.
Yeah. And here's, Chris, finally on this topic, the practical question about paying attorney's fees. Client still has to pay our firm up front and then hope to recover later. So I tell them, I don't know if you agree or disagree, I don't recommend staying in a lawsuit. If you've got a chance to get out of court and maybe you've invested, say, 5-10 grand in attorney's fees to maybe make this thing go away, you don't recommend staying in a lawsuit just on the hopes of recovering attorney's fees, do you? Or what do you think?
No, definitely not. At some point, and it's not fair, and I can't empathize with the clients. Like, hey, you've had to hire me, you've had to go through all this that you don't feel like you should have, and maybe you shouldn't have, but you are in it. This is how it goes, and this is just what you're stuck with. So take your opportunity, get out of the case. Especially, let's not forget that sometimes it's the person being sued. So it's okay, now this person's offering to walk away or to just settle for nuisance value when really they should have never brought this lawsuit. But you don't actually have a claim for damages. It's them bringing a claim against you. You're not going to recover anything. You just need to get out of this.
Yeah.
And yes, I'm sorry it took your time. I'm sorry you had to call me. No one likes to spend their time having to fight a lawsuit. But if I can get you out of it and you wake up tomorrow and you don't have a lawsuit, that's a win.
That's a win. And that often happens with torts. You'll often see torts in Texas not really have a provision for attorney's fees. So if you're being sued for something like negligence or whatever, all you can do is stand by and defend it. All right, that brings our show to a close. I've been your host, Phil Silverman. Chris has been my co-host. Like us, follow us, review us wherever you get your podcasts. And as a reminder, nothing in this show has been considered legal. Is to be considered legal advice, and this has all been for entertainment purposes. If you have a legal question, email us at info@silblawfirm.com. That's info@silblawfirm.com. Tell us you want it publicly answered in the podcast. Everybody have a great weekend.